The Honorable, the Supreme Court.
Thank you all very much. And please be seated. And Madam Bailiff, when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Enry Petition of Randolph Davis Solar, LLC, case number 25 AP 005. Appellant Michael Binder is self-represented. Seated at council table with Appellant Michael Binder is Appellant Joan Allen. Representing the appellee, Randolph Davis Solar, LLC, is Attorney Kimberly Hayden. Representing the appellee, Department of Public Service, is Attorney Caroline Daniels.
Okay, just a few ground rules before we start. Let's make sure everybody's clear about it. Mr. Binder, you arguing, you're the only person arguing on your side of this case?
I believe so.
Okay, and you understand you've got 15 minutes. You're welcome to reserve some time to get up again after your opponent speaks, but it's up to you to reserve the time. And if you've asked for a light at when you've got a minute or two left, that's fine. I don't know if that's happened. Is that the way it, has he got it structured? Okay, good. Then on the appellee side, Attorney Hayden, are both of you arguing? I'm sorry, I can't hear you.
Splitting our time evenly,
So you've got that worked out with the lights, yes? Okay, all right. Okay, so Mr. Binder, come on up. And so when you're ready, please, for the record, introduce yourself and then go ahead.
Good morning. My name is Michael Binder. I am an appellant in this case, and I'm speaking for myself and co-appellant Joan Allen. We are grateful for the opportunity to be here. I just learned this morning that I must ask permission of the court to show some of the record evidence.
Yeah, we're fine with that.
Okay,
Go ahead. Yeah, but let me just tell you, every time you step away from, we have a recording, and there's a live stream, I assume, yeah? There's a live stream this morning. Every time you step away from that microphone, your voice is going to fade out. And so to the extent you can stand with the microphone, you're going to be much better.
Right, I think I can point from here
There
while
you go.
talking in the
All
microphone.
right, all right.
Okay, so if it please the court, we'd like to start with the erosion issue. And to show some of the record evidence, we want to show something that is extremely site-specific. And that is the grading contours on the site plan are at 1 foot intervals of elevation. Every fifth elevation is bold and in dark and is labeled. And this is a cross-section of a berm on the road. And the reason I want to show it is that the grading diagram of the road is at the same scale as the topographic contours of the site. And every one of these contours on the road is connected to a contour on the site. So for example, let's look at the 675-foot elevation above sea level. Prior to construction, it runs across like this and exits over here. After construction, this 675 contour ascends right here up the embankment, across the 12-foot roadbed, down the embankment, and continues where it left off and exits on stage left. This is extremely site-specific. These are the fingerprints of the road. Now, in this case, we could take a look at 20B, for example, and we know that it's at 675 after the road is constructed. But prior to construction, we can see that it was at 667, so it's elevated 8 feet. Similarly, point C here is elevated 9 feet, and that's what creates the berm. This berm is about 37 or 8 feet wide. The 12-foot roadbed is on the top of the berm. Now, using that sort of as an introduction to how this is looked at, we turn to go up the road a few hundred feet, and we have a dispositive reason to deny this project. What we have here using the same methodology is a trench. Basically, they've cut a 6 foot deep, 37 foot wide trench here. The 12-foot roadbed is the bottom of this trench. When rain falls on this roadbed, and when rain falls on this embankment and goes to the roadbed, it will want to flow downhill. And the only way for it to flow downhill is to go down the roadbed, because this road here has no roadside ditches. It has no culverts. There is no way for water to get off this road. It's basically a trench. By the way, that's located right here on by the way, this is all going uphill. This is the high point of the road. This exhibit, MV35, which is on printed case page 216, is the same road annotated with blue arrows pointing downhill. And the purpose of this is to show that there's acres of land, steep headwater land, uphill from the road, and that rain and surface water and snow melt will come pouring down this hillside into this trench. And once it's in this trench, as we point out, there's no way out except to go further down. This is the ingredients for a washout. This could be a environmental catastrophe with the rainfalls that we get nowadays. So to understand how this project could possibly get a certificate of public good, it's a two-step process. First, the Agency of Natural Resources looks at the site plan, and when they look at the site plan, they look right up here at the impact area calculations, and they see that it's 0.3 of an acre impervious surface. That does not meet the threshold of a half an acre for an operational stormwater permit. It does meet the threshold of 1 acre. In fact, it's 11.6 acres limits of disturbance, and therefore it requires a construction stormwater permit.
Well, it depends on what you call an impervious surface.
I agree. And in reality, this 0.3 of an acre number is not correct, as we will argue soon, because it does not include the impervious surface of the solar panels. But for the moment, let's do a thought experiment.
But how are you, your position is that the solar panels were an impervious surface. And as I understand it, it was determined that they are not because they're elevated above the ground and the water still can drop down and percolate through.
That is correct. They are not impervious. Okay.
Oh,
I mean,
you agree with that?
No, yeah, they are not impervious. However, they haven't included that here. But for the sake of argument, just for a moment, let's pretend that this number is correct, that let's pretend that there's only 1 or 2 rows of solar panels here, and that the total impervious surface is less than half an acre. The point that I'm trying to make is that a project with less than half an acre of impervious surface can be an environmental catastrophe. It doesn't require half an acre, but the Agency of Natural Resources looks at this, and the only thing they say, they don't look at any of these contours, any of this grading line, none of this road is relevant to them. The only thing that's relevant is what they see here, less than a half an acre, and therefore it does not require operational stormwater permit. So that's step 1 in how this managed to get CPG. The next step comes here when on the final order on page printed case 12, the Public Utilities Commission says they are satisfied that the applicant's compliance with A&R's permitting requirements is sufficient to prevent unreasonable soil erosion at the facility. What does that mean? Are they saying that because it's less than a half acre and doesn't need a permit, it can't cause erosion? Well, I think that's not the case. The road proves that something less than a half acre can cause erosion. The other option is that they're saying that the fact that it has a construction stormwater permit, which has temporary measures to prevent erosion during construction, will somehow prevent the road from washing out after construction. And that makes no sense either. They can deploy every silt fence in the state of Vermont to the site during construction, and that road will still wash out after construction.
Maybe I misunderstood. I thought your issue was about the solar panels, that the solar panels created an impervious surface that was not accounted for under the requirement relating to erosion prevention and sediment control.
That is our position. But I'm trying to make the point that even if that wasn't, just to separate that out, that this road in and of itself is a dispositive reason to deny this project. You don't even need to look at the solar.
But the road, you didn't argue this below, did you?
Yes, I have in my arguments. I've stated that.
Well, you didn't appeal it to us, did you?
Well, we appealed the decision. What we're appealing is the deference of the Public Utilities Commission to the Agency of Natural Resources. The Agency of Natural Resources does not look at any of these contours in this grading diagram. They decide what needs a permit. But
is your road argument based on more than a 25% slope?
What about 25?
Is your erosion argument regarding the road based upon your
No,
argument?
not at all.
Doesn't have to do with the
No, no,
25%.
gouging a trench on a steep hillside slope, okay? I mean, that profile here looks more like an aqueduct than a road. I mean, there's no drainage. So, I mean, there's no way out of that trench for the water. It will wash out. And the issue here is whether the Public Utilities Commission is correct to defer in the erosion criteria to the Agency of Natural Resources, which hasn't looked at any of this. And of course, the Public Utilities Commission hasn't looked at it. They don't look at these diagrams either because they have deferred to the Agency of Natural Resources, which has theoretically looked at them, but has not. So permitting at the Agency of Natural Resources is not adequate to prevent this type of erosion. Okay. Now, perhaps to get back to the question you asked about the solar panels being on slope. What I've testified for is that a number of jurisdictions, other states, have had fairly lax rules for solar development because in the early days of solar, the industry fairly self-regulated and they tended to do their developments on shallow slopes and steep land. And so it didn't really much matter what you did in a solar development because flat land is quite forgiving of erosion. But other jurisdictions now have realized that solar panels, the rainfall that comes off them is concentrated. And when they're not lined up with the contours of the land, it becomes further concentrated. And so state after state has made, in response to catastrophes on their soil, has come up with new rules. For example, New York and Maryland.
Was this before the tribunal below? This exhibit, was it before is this something that you introduced?
It's in the record.
It is in the
Yeah,
record.
this is exhibit neighbor intervenor MB40. Unfortunately, it's not in the printed case, but it's certainly in the record. It's a very concise 6-page exhibit that's illustrated. This illustration here is from it.
See your lights blinking, just make sure you understand your time is, but you see your light, yeah.
Yeah, let me see. I'm
Okay.
10 minutes into this already.
All right,
Okay.
all right.
So in Rhode Island, I like the Rhode Island description because this bold face that's here, I didn't put it in there. That's actually in their rules. And it says the design should include adequate measures to achieve and maintain sheet flow from the drip edges of the panels, such as level spreaders, terraces, and or berms. New York and Maryland require level spreaders, terraces, or berms on any slope over 5%. And New York and Maryland also require that if the slope is 10%, it have a fully engineered site plan with calculations of all the water that comes off the panels and how it is to be managed. So Pennsylvania has amended the rule, came in with slope rules in 2019 and modified them again in 2021. And in that same exhibit, MB40, we have from Pennsylvania now includes in the most recent revision, solar panel farm projects completed on slopes exceeding 15% can be permitted. However, they would be pushing the threshold of current constructability. Okay. It is really difficult and challenging to put solar panels on a slope this steep. Now, in Vermont, we have this legal fiction that solar panels are not impervious and that rain passes through them as if it's not there. And that's why Vermont cannot, in any rational way, have rules and best management practices for solar panels, because in Vermont, you can put the rows of panels as close together as you want with no disconnection distance. You can put them on any slope. You can put them any height off the slope. You can put them any orientation of the slope because rain passes through them as if they're not there. There is no drip edge. There is no runoff in the state of Vermont with this legal fiction. As long as that fiction is sustained, there is no way for Vermont to sensibly regulate solar panels. The issue on the appellate level here is that the Public Utilities Commission has not looked at this, has not paid attention to this. They have deferred entirely to the Agency of Natural Resources, which has no rules and does not consider slope.
And what is it that you're asking for? If you were to prevail here, what would the mandate look like?
I think the mandate has to be remand this case to the Public Utilities Commission and tell them to consider the evidence that's in the record. Instead of deferring to the Agency of Natural Resources, which does not look at this evidence, does not consider it, they have no slope rules. I think that it needs to go back and have the commission.
Well, the
Do
PUC
their-
has a slope rule, doesn't it?
What's that?
The PUC has a slope rule, 25% rule?
No, they don't.
That's not them?
No, that's the
Whose
town of
rule is
Randolph.
that? Huh?
That's the town of Randolph had.
Well, Yeah, okay,
Okay.
but they complied with that rule, didn't they?
No, they did not, actually, as a matter of fact.
How so?
Well, they still have solar panels on greater than 25% slopes. And once again, the Public Utilities Commission has not looked at the evidence that's in the record. If you invite me to, I have more posters here and I'll be glad to show it to you. Prepared to show you why.
Well, it's your time. I want to make sure you understand. It's your time.
Okay.
And 15 minutes when it's up, you're going to have to sit down.
Well,
So-
let's start with Exhibit MB 39 called a slippery slope. This is in the printed case. And this shows the original site plan for the case. I lost my pointer here. Here it is. And I've put red dots on the 830 foot elevation here. And in the second site plan, look what's happened to it. They've distorted the contours here in such a way that they could then come up with this. Since they cannot draw the contours properly, then when they create a slope layer, it's artificial also. There's no such thing as a natural slope layer in the state of Vermont or anywhere else that looks like this. This is fully contrived. It's as phony as a $3 bill. Here, is the same site. This is the preliminary site plan that they showed to the town, and it has a LiDAR slope layer superimposed on it. They produced this in less than 2 hours on request because the LiDAR slope layer can be produced with a click of a mouse. And what we see is this. If you look here, here's an area with less yellow, and here's another area with less yellow. When they tried to remove the panels off this very steep area, they tried to put it here and here, but they have not succeeded. Okay. So am I out of time?
Yeah.
Okay, I'm sorry, then I guess my time is up. Thank you for your attention.
Thank you very much. Who's going first? Yeah.
Good morning. If it may please the court, I'm Kimberly Hayden from Paul Frank and Collins, and I represent the appellee Randolph Davis Solar.
Thank you very much.
I will be taking less than probably the 7.5 minutes. I plan to address orderly development and preferred siting. I'll speak to those two issues, which were the other two issues on appeal, very quickly. The town of Randolph did file 2 separate letters designating this site as preferred. After an initial letter was filed and they asked the applicant to correct the site plan to move the panels per a surveyor off of slopes exceeding 25%. The commission wanted to make sure that the town understood that in fact had been done. The town filed a second preferred site letter under Commission Rule 5.103. The requirement for preferred siting is that the town provide a letter. The town did that. There's no question about it. The PUC relied on that and made their decision that this is a preferred site that qualifies for a solar project under its rules.
The appellant argues that the actual evidence was the solar panels were built on slopes exceeding 25%.
I've heard that, and that was presented below. There was not an evidentiary hearing below, but that was part of Mr. Binder's numerous arguments and exhibits submitted below. But the survey that was required by the town was conducted by a licensed surveyor. It was reviewed by the engineer that prepared the site plans, and the commission agreed with the appellant that that evidence proved that the solar array had been moved off of slopes exceeding 25%.
Was the survey in evidence?
Yes, it was.
Okay.
Yes, and it's all cited in our brief, and I apologize, but we don't have a lot of time. It's fully cited. It's cited also by the hearing officer's findings on erosion control. The So we have that evidence as far as preferred siting.
Ms. Hayden, how much deference should the Agency of Natural Resources get in a proceeding like this?
I believe they get deference, but the commission, and that's a good question because the commission did not defer entirely to the Agency of Natural Resources here. There was significant evidence in the record that site-specific erosion control measures would be included in the construction and for the design of the project so that there would not be any erosion during construction or following construction of the project. We've cited those in our brief. The Agency of Natural Resources did issue a low-risk permit for the project. It falls under their general permit, construction permit. It was designated low risk notwithstanding that some of the slopes exceeded 33% on the road area. But again, there are very site-specific erosion control measures that are contained in the low-risk handbook that become part of the site-specific erosion control that a developer has to abide by. And in addition to having those two separate erosion prevention, sediment control measures that were identified in the record, we recite them in detail in our brief on appeal as well. The appellant's expert civil engineer also testified that in his experience having installed, designed for and worked with developers on installing many other solar operations, he had not seen the kind of catastrophic erosion that Mr. Binder is referring to. Mr. Binder, and this is cited in our brief, is not an engineer. He's never prepared an erosion prevention sediment control plan, and he has never applied for a permit before the Agency of Natural Resources.
Did they introduce expert evidence about erosion in the?
They did not. They did not. And I was not able to see all of the exhibits that Mr. Binder was showing the court just now. I took him at his word that these were submitted to the commission. The commission has a practice generally of accepting evidence, and especially from pro se parties. The commission did not find Mr. Binder's arguments compelling or substantiated, and there was no expert evidence that was offered to support the appellant's contentions here. Separately, the Agency of Natural Resources did file comments and in fact requested judicial notice of its permit in this case, the low risk authorization under the construction general permit, which again, we refer to, I added to our printed case, the full low risk handbook pages, and they're referenced in that section of our brief, which begins on appeal, begins with the stormwater issue.
Counsel, would you refresh my recollection? What's the maximum grade on the road?
The maximum grade, it does not, it's a low risk permit, and the grade, the grade does not exceed, it's between 33% and 50%. But again, the low risk handbook contains measures for mitigating the movement of soil off slope, both during construction as well as a permanent measure. And that was a finding that the commission made in its order approving the project.
I'm just trying to visualize rain or surface water going down a 50% grade.
The record indicates the exact slope along the road. The access road in some places was more steep than others, but it is a gravel access road that has stormwater control and soil stabilization on either side of the road. I'm not, the evidence about a trench and water running down a trench, that was not something that was evidence in the case, and it's not clear from the erosion control plans that were submitted in the case that the PUC relied upon. These instances that Mr. Binder referred to today to the court. The low risk handbook, we did include it in our printed case. It was in the record below so that the commission, or I'm sorry, so that the court was able to see an example of a road, which we refer to in our brief, that does appear to be going up a very steep slope. with the measures that are installed in place, including vegetation and stabilization surrounding the road once it is installed, and it is a gravel road, the evidence in the case was that this project will not result in undue erosion. Orderly development was the final issue that was raised by Mr. Binder. The commission referred to the statute, which requires that there be a showing of undue interference with orderly development of the region. In this case, there was no showing of a regional impact. There was no evidence of a regional impact whatsoever, let alone an undue regional impact. The commission did give due consideration to the town plan, but was very clear that it understood the distinction between Section 248 and Act 250. And in Act 250, there's a compliance standard with the town plan. That is not what Section 248B1 states.
Right, I understand that, but do you think we've gone too far in our cases? The city of South Burlington case, the older 70s case, I mean, I have wondered whether or not we have been entirely consistent with that in the subsequent decisions. The Rutland Renewable case, the Apple, whatever it was case.
Apple Hill Solar?
Apple Hill Solar.
And how, I'm not sure what I understand.
Well, I wonder if we have gone beyond what it is that we said in that city of South Burlington case, where it was, I thought, very specific to the question of compliance with local zoning regulations. And beyond that, it seems as though we have taken a much more expansive view of that sort of language in those other two cases.
I guess I would not agree with that. The current case is not about a zoning regulation.
Right.
It's about a statement and a plan,
But I'm talking about the town plan.
the town plan,
Yeah.
with not a zoning regulation.
Yeah, right.
And the commission
So
will
there's one
give,
distinction there.
there's one distinction, and the commission will give deference to, they'll consider a zoning regulation when they look at a town plan. I don't think they look at it in isolation, but I think the most important thing here was that they were looking at the facts. They were looking at the array being located and moved to a location that was off the 25% grade. And they considered the evidence from the experts, and which is consistent with the stormwater regime, that this project had a low risk of causing erosion, even as designed, and particularly given the mitigation measures that would be put in place.
Okay, thank you. Let's see how much time we've got.
Kelly has 4 minutes and 45 seconds.
Okay.
Good morning, Your Honors, and may it please the court.
Please identify yourself and your client.
My name is Caroline Daniels, and I represent the Appellee Vermont Department of Public Service.
Thank you.
Thank you. I would like to address the issues of preferred site and orderly development in support of this court's decision to.
Attorney Daniels, I apologize for interrupting you, but let me just ask at the beginning, what is the standard of review this court should use?
The standard of, it's a deferential standard of review. The appellant's burden is to establish clear error. And the department posits that appellants have not identified an clear error with the commission's underlying decision.
Does that deference extend to A&R as well?
I believe it's a different standard that would apply, because this standard applies to the commission's review, the commission's determinations. And the deference that would apply to A&R would be the deference that the commission is giving to A&R. So it's, my understanding is that it's a different standard. Are there further questions on?
And as you're aware of California Supreme Court decision recently, they just said that the standard of deference for utility commissions should be less deference. It was just decided recently.
I am not aware of that. Thank you for bringing that to my attention. I would say that not having read that opinion, I would say
I'm not
that
holding it to any.
I would say
we
that
don't need a decision.
the commission's decision in this case, I think it's important to emphasize that the commission's decision in this case is well supported by factual determinations that are based on evidence that was presented into the record. The commission considered the evidence as is its role, it weighed the evidence presented to it, made findings, and then exercised its discretion based on those findings. And I don't think that the department does, the department's position is that the appellants have not identified a way in which those findings were erroneous or that the commission overstepped its legitimate exercise of discretion on any of the issues. There's the statutes we are also not dealing with any issues of ambiguous statutes, at least on the issues of the preferred site requirement and orderly development. The appellants have not identified clear error in the commission's.
What was the evidence below that a road with at least part of it, a 50% grade would not cause undue erosion?
So I can't speak to the agencies of natural resources determinations on erosion or the commission's review of that necessarily, but the commission did find that the solar project is not in compliance with the town plan's provision prohibiting development of energy facilities on slopes greater than 25%. But as this court has held in previous decisions, that non-compliance with certain provisions of the town plan are not determinative of the issue of orderly development.
I thought the applicant refiled that there were changes in the plan that were submitted and approved,
You're correct.
and that the changes were established the project on slopes less than 25%.
Correct.
Okay.
But there's a distinction. The later versions of the site plan moved the solar arrays off of the 25% grade, but there was still project infrastructure on other parts of that hill that that the commission looked at. And so the commission determined that the project was still on slopes greater than.
Okay. Thank you. Your time has expired, I think. Yes. Thank you very much. Does the appellant have any more time?
Appellant has no time remaining.
Okay, please call the conclusion of the hearing.
The next hearing for the court is scheduled for 1 o'clock this